will be majorly focusing on the ITLAWS angle. But before that, I will be giving a quick background also about what is happening in this area. So these are the 13 things which I will be covering throughout this. I think half an hour has been allocated to me, so I will be speaking on following points. So we all know that climate change, global warming are the issues which are constantly happening. And we see, if you see this from the perspective of law of the sea or ocean, because we see that in law of the sea, uh, and also like oceans are very much relevant because 90% of global trade happens through ocean. So
Mohit,
when
your
we see
PPT is
climate change,
frozen. Mohit, you can reshare your PPT.
no, can you? Is it changing now?
Yeah, the PPT is not visible. Can you reshare?
Sure. So I'm again sharing it. Just a moment. Is it visible now? Is it visible now?
Yeah, perhaps yes. I think we can continue.
Okay. Thank you. Okay. Like if we connect ocean and climate change, of course, if you see the data, some of the reports published by IPCC and other scientific literature, we can observe that there is a relationship between climate change and the ocean. And if you see the past, we have seen that in last 200 years that oceans have absorbed a significant amount of carbon dioxide, and also the extra heat they are absorbing. But today we are seeing that because of the carbon dioxide which is being absorbed in the ocean, the acidification which is being caused and coral reefs are also impacted. And if the same level of global warming will continue, that oceans are heating up, and also there will be issues like sea level rise. They're already happening. Issues like currents, the ice melting, and all those issues can happen and are happening at a very high pace. Now, in this context, what is the international response which has been felt? We all know that there are certain treaties which were negotiated, like UNFCCC, then Kyoto Protocol, and finally the Paris Agreement of 2015. In Paris Agreement, we had a shift. Earlier, it was a top-down approach. In Paris Agreement, we took bottom-up approach, which means that countries determine the target which they can achieve. They were voluntarily determined target for carbon emission reduction in the Paris Agreement. So this kind of developments which were happening. But today's topic is related to advisory opinion, how advisory opinion can help us in dealing with those issues or determining the scope of obligation which the countries have. Now, in this context, when you talk about advisory opinion, presently three advisory opinions are pending. One is in ICJ, another is in ITLAWS, another is in Inter-American Court of Human Rights. More or less, all are talking about the same issue, determining the scope of obligation which the state have with respect to preventing this global warming and all those issues. As I told you, my focus will be ITLAWS, the litigation, the advisory opinion which has been sought from ITLAWS. But before that, a quick background. Firstly, talking about advisory opinion. When it comes to ICJ, it's very clear that ICJ has an advisory jurisdiction. In the same way, when it comes to Inter-American Court of Rights, these things are clear. But when it comes to ITLAWS, there is some kind of uncertainty whether ITLAWS has advisory jurisdiction or not. That portion we will be covering in the later half of the session. When it comes to seeking advisory opinion, this is the better option because, for example, we talk about UNCLOS. Amending a treaty is very difficult. So it's better that we can seek an advice from the ITLAWS, and ITLAWS can clarify the scope of obligation of state parties. So, for example, by virtue of the provision of UNCLOS, which are related to marine pollution, for example, Article 193. So that's why advisory opinions are very important. For example, some of the international scholars, particularly Daniel Bodesky, has pointed out some of the benefit of advisory opinion. When we compare advisory opinion to the contentious litigation, one thing which can be said that advisory opinion are more general in nature, and as opposed to contentious litigation, there are two parties which are disputing parties which are fighting against each other. So whatever is being said in advisory opinion is more general in nature. And also when it comes to advisory opinion, for example, when we see the litigation, the advisory opinion which has been sought from ITLAWS, the submission has been sought from states. So many states have given the submission in the ITLAWS. Also, international organizations have given their own submission. to its laws. So, like the voices of the streets can be heard to a greater extent when it comes to advisory opinion. Furthermore, advisory opinion can clarify, elaborate on the provision of a treaty. So that way, advisory opinion can be very important. Particularly, they will be important for clarifying the scope of a provision which is there in the treaty. So this recourse to advisory opinion has been sought. The ICJ advisory opinion, as Dr. Atul pointed out, the General Assembly unanimously passes the resolution whereby General Assembly has requested advice from ICJ on this particular issue, that what are the legal obligation of countries in relation to climate change, as well as what are the legal consequences for countries that have caused significant harm to climate change. So this advisory opinion is already being filed in ICJ. Furthermore, two other advisory opinion, one has been sought from ITLOS, another has been sought from Inter-American Court of Human Rights. So as I told you, my focus will be on advisory opinion which has been sought from ITLOS. Now, when we see advisory opinion, the history, if you see, compare the advisory opinion sought from ICJ in past. So there are 27 advisory opinion which ICJ has rendered till now. But when it comes to ITLOS, it's only two advisory opinion which ITLOS has rendered till now. Now, when it comes to ICJ, it has broader mandate, but when it comes to ITLOS, it has narrow mandate, only deals with the law of the sea issues. Uh, but when we see ITLOS advisory jurisdiction, if you see the law of the sea convention, and if you trace that, whether this term advisory opinion has been used in the law of the sea convention, we can find that there is one place where this term advisory opinion has been used. It has been used in the context of seabed dispute chamber. So Article 191 of the Law of the Sea Convention says that seabed dispute chamber of ITLOS can render advisory opinion. Apart from this provision, in none of the place in the ITLOS this term advisory opinion has been used. This is the reason many scholars argue that ITLOS in general don't have advisory jurisdiction. The advisory jurisdiction, as per UNCLOS, only vests with seabed dispute chamber. Now, when we see the part of UNCLOS which is related to dispute settlement, there also this term advisory opinion has not been.
Mohit, you can change the slides if
Okay,
slides.
which no, I'm
Slide.
changing the slide. Okay, which can you see Article 21 on the slide?
No. Can you change the slides? Yeah. You're perfectly audible. The slides are not changing, so that's the only.
So now, can you see Article 21?
Yeah. Now it's fine. Yeah. Please go ahead.
Yeah. Okay. So point which I was making here is that when you see UNCLOS, it's a very debatable issue that whether ITLOS in general has advisory jurisdiction or not. Because this advisory jurisdiction has been used in UNCLOS only in the context of seabed dispute chamber. So if there is any dispute related to area or deep seabed, then this seabed dispute chamber of ITLOS can be approached. In general, ITLOS expressly UNCLOS don't recognize advisory jurisdiction of ITLOS. But again, there are certain provisions which are relevant for the issue which we are discussing as of now. Article 121 of the statute of ITLOS. Atul, can you see Article 120? Article 21 in your slide as of now? Like, I want to just ensure that the slides are
What needs to be done? Wait a second. Yeah. Mohit, you can use the PowerPoint window instead of using the full screen, so that
Okay.
the slides could change accordingly, right?
Okay. Should I use like this?
Yeah. Now it's fine. Yeah. It's fine.
So I will be using like this. I will be doing
Yeah,
it.
yeah.
Like,
Yeah.
Okay. So there are certain provisions which are important to determine whether ITLOS has advisory jurisdiction or not. So first provision which is relevant here, because UNCLOS expressly don't recognize this thing that ITLOS in general has advisory jurisdiction. There are certain other documents which are important here. First of all is Article 121 of the Statute of the Tribunal, which means the Statute of the ITLOS. So Article 121 of the Statute of ITLOS says that the jurisdiction of the tribunal comprises all disputes and all applications submitted to it in accordance with this convention, and all matters is specifically provided for in any other agreement which confers jurisdiction on the tribunal. So if you see this provision also, it just starts by saying that jurisdiction of the tribunal comprises of all disputes. But later on it says, and all applications submitted in accordance with this convention, all or any other matter which has been mentioned in any other related convention or law of the sea related convention. So this is one provision which is often have been interpreted because of this wordings which have been used. I have bolded that as well. All disputes and all applications submitted. So there could be one interpretation that all applications submitted includes seeking advice from the ITLOS. Now there is one more provision which is relevant for this discussion, which is Article 138 of Rules of the Tribunal. Now 138 of Rules of the Tribunal specifically uses this term advisory opinion. It says that Article 138 of the Rules of Tribunal provides that the tribunal may give advisory opinion on a legal question if an international agreement related to the purpose of the convention specifically provides for the submission to the tribunal of a request for such an opinion. So here 138, which is the rules of the tribunal. Remember, this is not a treaty. This is the rules of the tribunal, which the tribunal has formulated. This document instead refers this term advisory opinion, and it says that advisory opinion can be sought on any legal question if an international agreement related to the purpose of the convention specifically provides for the submission to the tribunal of a request of such an opinion. So which means that maybe like for implementing law of the sea convention, there is a fisheries agreement which has been negotiated by the parties, and that fisheries agreement recognizes advisory jurisdiction of the ITLOS. So that kind of ad hoc agreement or separate agreement contemplating the advisory jurisdiction of ITLOS, that scenario can happen, is possible as per Article 138. Now, again, like these are the two provisions which I mentioned: Article 120, Article 21, and Article 138, which are relevant for the discussion which we are having. Now, looking at the past jurisprudence developed by ITLOS, so the question which we are discussing here is that whether ITLOS holds competence to render advisory opinion. Now, yes, ITLOS has rendered advisory opinion. At least one advisory opinion has been rendered by ITLOS. Basically, in the starting, I told you two advisory opinion, but this first advisory opinion was by Seabed Chamber. So that is of course not controversial because UNCLOS itself recognizes advisory jurisdiction of Seabed Chamber. But the second advisory opinion, which was sought by SRFC Sub-Regional Fisheries Committee, this advisory opinion was sought in 2015. So we can say that at least there is one occasion where in 2015 ITLOS has rendered an advisory opinion. Now, when ITLOS rendered this advisory opinion in 2015, which was sought from SRFC, again in that litigation, that advisory opinion as well, there was this question that whether ITLOS can give advisory opinion or not. So this issue came up there as well in 2015 in this litigation in this advisory opinion sought by SRFC. So while answering the question which ITLOS was answering in that advisory opinion was that whether ITLOS hold competence to render advisory opinion. So in answering this question, ITLOS looked at both of the provisions which we discussed a while back, Article 21 and Article 138 of the rules. Now, as we already know that Article 21 is specifically, although Article 21 don't uses this term advisory opinion, but it says that the jurisdiction of ITLOS comprises of all dispute and all applications submitted. So this word "all applications submitted" was interpreted by ITLOS in the advisory opinion sought by SRFC, and yeah, the ITLOS in the SRFC advisory opinion said that the wordings in Article 121 shows that both contentious as well as advisory jurisdiction lies with ITLOS. So in SRFC case, advisory opinion, ITLOS recognized that by virtue of Article 21 of the ITLOS statute, it can render the advisory opinion. But there were certain other observations which were given by the ITLOS in the SRFC advisory opinion. In that advisory opinion, ITLOS also looked at Article 138 of the rules of the ITLOS, and with respect to that, ITLOS said that there must be a separate treaty or agreement which should grant advisory jurisdiction to the ITLOS. Because 138, the language of 138, as has been mentioned in the slide which is being shared, Article 138 says that ITLOS may give an advisory opinion on legal question if an international agreement related to purpose of UNCLOS specifically provides for submission to ITLOS of a request for such an opinion. So, like by interpreting 138, the ITLOS in the SRFC advisory opinion said that there should be a separate treaty or ad hoc agreement which should give advisory jurisdiction to ITLOS. In that case, only ITLOS will have advisory competence. And the courts further said in the SRFC advisory opinion that UNCLOS is silent on the advisory jurisdiction, but if ad hoc treaty will be there related to purposes of UNCLOS, then ITLOS can very well render the advisory opinion. Now, overall, if we see what we can say that the purpose of Article 21 of the ITLOS statute and also the purpose of Article 138, the overall purpose is that because UNCLOS is a very broad treaty, that's why it's called as Constitution of the Ocean. So there are many regional fisheries treaties. There are many other regional environmental organizations have been created through treaties. So those separate treaties can give advisory jurisdiction to ITLOS. So that is the purpose of Article 121. Now coming back to the present litigation which has been filed, which has been present advice which has been sought by a small island developing nation or small island states. In this advisory opinion, first important thing to note is that these countries, the three countries, Antigua, Bermuda, and Tuvalu, they first of all they have entered into an agreement which is called as the Agreement for Establishment of Commission of Small Island States on Climate Change and International Law. So they have entered into this treaty or ad hoc agreement on 31st October 2021. So these three countries entered into this treaty, and by virtue of the provision of this treaty, particularly in one of the provision of this treaty, Article 3, it has been mentioned that the commission which has been created through this treaty can seek advisory opinion from ITLOS. So what we can say that the entire purpose of signing this, because this treaty is very small, it has only 5 articles. The entire purpose why this treaty came into being was that so that the commission which has been created through this treaty can seek advisory opinion from the ITLOS. So as per Article 2 of this treaty, the purpose of this treaty is to contribute to implementation and progressive development of international law. And in particularly, it has been mentioned that to contribute to the progressive development of international law through development of jurisprudence of international courts and tribunal. So this treaty has created a commission commission on small island states. This treaty is open to membership from other small island states as well. So as of now, there are other countries which have become party to this treaty. Palau, Republic of Vanuatu, and many other countries have also become party of this treaty. But original signatory of this treaties were these countries: Antigua, Bermuda, and Tuvalu. Moving forward, if you see this treaty, particularly for our purpose, Article 2, Clause 2 of this treaty is important. It specifically says this thing that the commission shall be authorized. So there's a commission which has been created through this treaty, and it has been mentioned that commission shall be authorized to request advisory opinion from ITLOS on any legal question within the scope of UNCLOS consistent with Article 21 and Article 138 of its rule. Specifically, the power or authority has been given to the commission which has been created through this treaty to seek advice from ITLOS. So what we can say is that the only purpose why this treaty of 5 articles came into existence was because they had to seek advice from the ITLOS. And as I already told you in the SRFC advisory opinion of 2015, ITLOS already said this thing that that in order to seek advice from ITLOS, there has to be a separate treaty which should recognize advisory jurisdiction of the ITLOS. Now, moving further, the Commission on Small Island State, which is called as COSIS, which is Commission on Small Island State, which has been created through this treaty. It has requested advisory opinion from ITLOS, and the question which has been asked from the advice which has been sought from the ITLOS is that what are the obligations under UNCLOS to prevent, reduce, and control pollution of marine environment from climate change, and what are the obligations under UNCLOS to protect and preserve the marine environment in relation to the climate change impacts. So these are the two questions which have been asked from the ITLOS. Now, as I already told you, the only purpose of this agreement is to just take this advice. Now, important thing to discuss here is that can ITLOS render this advisory opinion requested by the Commission on Small Island States? At least there are 2 obstacles. In the existing literature, some of the authors are still they're arguing that ITLOS can't. ITLOS should decline this advisory opinion. At least 2 obstacles which I will be discussing here. First obstacle is that if you read the language of this agreement, which has been entered into in order to seek this advice from the clause. If you see the language of this agreement, it is specifically do not confer any advisory jurisdiction to it laws. I will be discussing elaborately this first point. And there's another point which I will be discussing, which is that by seeking such advisory opinion, it will be bypassing the dispute settlement apparatus, which has been already given under UNCLAUSE. So I will be elaborating on these 2 points in the limited time which has been left now with me. So first, we're talking about this first point. Now, now, if you read this Article 21 of ITLAS statute carefully, there are certain prerequisites when it comes to Article 21 of the ITLAS statute. Now, Article 21 of the ITLAS statute, first of all, recognizes this thing that there must be an international agreement which should which should confer advisory jurisdiction on ITLAS. So apart from UNCLAUSE, there should be a separate agreement which is conferring advisory jurisdiction on ITLAS. Now this thing was pointed out by in the ITLAS SRFC advisory opinion as well, where the tribunal said that there should be an ad hoc agreement. That agreement must expressly and specifically confer advisory competence to ITLAS. So this wordings are very important. That separate agreement should specifically confer advisory competence on ITLAS. Now, if we see this, see the provision in the agreement which has been signed, the COSIS agreement, the agreement which I'm talking about, Commission on the Small Island States, the agreement, the 5-article agreement which has been entered into by Small Island States. If you see the relevant article of this agreement, which is Article 2, Clause 2, it says that Article 2, Clause 2 of this agreement, it only authorizes the Commission to request an advisory opinion from ITLAS consistent with Article 21 of ITLAS and Article 138 of the rules. The provision does not specifically confer advisory competence to the ITLAS. Now, if we already seen the language of Article 2, Clause 2, which I have shown, mentioned here. If you read this this particular provision, which is Article 2, Clause 2 of the agreement, it nowhere specifically confers advisory jurisdiction on the ITLAS. It just says that Commission can seek advice from the ITLAS. It nowhere says that it is conferring advisory jurisdiction on the ITLAS. And since in the SRFC advisory opinion, it was specifically said by the tribunal that the ad hoc agreement should expressly Atul, I think I went in full screen. Was the PPT is visible? Can you please say?
Yeah, everything is visible. I think the slides are also moving, and we are perfect. You're perfectly audible.
Okay, should I keep like this or full screen?
Yeah, this is fine. This is fine.
This is fine. Okay.
Yeah.
Okay. Okay. So the point here is that in SRFC advisory opinion, it was made very clear that other agreements should specifically confer advisory jurisdiction on ITLAS. But when we see Article 2, Clause 2 of the COSIS agreement, we see that this agreement only says that the Commission can seek advice from ITLAS. It nowhere says that ITLAS has been conferred an advisory jurisdiction. This is the first obstacle I was talking about. Now talking about next problem, next issue. Now seeking such kind of advice from ITLAS may be abusive use of Article 21. Why it will be abusive use of Article 21? Because it will become very easy. Two countries will just sign a bilateral treaty, and they will decide that this particular matter this particular advice has to be sought from the ITLAS. So they can bypass the dispute settlement provision under UNCLAUSE, which was negotiated after a lot of disagreements were there, but finally that dispute resolution provisions were negotiated, and that entire part don't use the system advisory opinion at all. It talks about contentious jurisdiction, but it nowhere Part 15 dispute settlement related part of UNCLAUSE uses the system advisory opinion. Now it would amount to hijacking the ITLAS to make it adopt a specific interpretation of UNCLAUSE. So parties, whenever they want, they will just sign a bilateral treaty and will approach ITLAS and will seek some kind of interpretation of the provision of the law of the sea convention. So it will make things very much easy. And for example, also if you see the when this ITLAS advice was sought from the ITLAS, many countries made submission. Now, if you see the Indian submission, whether India is supporting this kind of advisory jurisdiction of ITLAS or not, if you see the Indian submission, once this advice was sought from the ITLAS, many countries made the submission. India also made the submission. India specifically made it clear neither convention nor the statute provides for advisory jurisdiction. Now, if you see Article 21, it don't uses this term advisory jurisdiction at all. This term advisory jurisdiction only comes when it comes to rules of it, which have been created by the tribunal, which is Article 138, which have been created by the tribunal. Now, India's view on this is that this Article 138 are being created by tribunal itself. It is not reflecting the consent or the will of the state. Tribunal can't make it rules in such a manner whereby it goes against the unclause. So in the view of India, like it is as has been mentioned here, I have highlighted it also. It is the only text that makes provision. So Article 138 is the only provision which makes use of this term advisory opinion. The relevant portion of Article 138, we already seen it. So India is saying that it is submitted that the rules of the procedure of tribunal is not a negotiated text between the state parties. Rather, it is adopted by the tribunal itself. And tribunal, while framing the rule, can't go against the provision. Now, India is of the view that ITLAS should decline such kind of advisory jurisdiction. There's another argument which India is making, apart from this particular argument that unclosed don't contemplate advisory jurisdiction of ITLAS. Yeah, of course, it contemplate when it's come to seabed dispute chamber. But apart from that, unclosed don't contemplate about advisory jurisdiction of ITLAS. Apart from this argument, there's another argument which India has why it is saying that ITLAS should decline the jurisdiction. The argument is that this particular matter is more related to climate treaties. It is related to UNFCCC, Paris Convention, Kyoto Protocol, but it's not very much linked with the Law of the Sea Convention. So Indian argument is that there are specific treaties which are dealing with this matter. Climate change treaties are there because when it comes to Law of the Sea Convention, the part which is dealing with marine environment, it is talking about the pollution from the ship, pollution from the land. So it is not specifically talking. UNCLOS is not a treaty which is specifically talking about climate change. The treaties, the relevant treaty, there are already in place the relevant treaty which are talking about only about climate change, like UNFCCC and all the treaties like Paris Agreement. So India's argument is that there is this matter more fits those treaties rather than UNCLOS. So this can be a ground why ITLAS should decline the jurisdiction. So ultimately, like if you see the Indian submission to the ITLAS, it is saying that question raised before the tribunal is primarily to determine the obligation of the state parties to the UNCLOS in relation to climate change. It is not related to Law of the Sea, so ITLAS should decline it. Now, in conclusion, what few points which can be made here is that if ITLAS will entertain this litigation, of course, it is likely that it can become a public interest litigation kind of thing. Many countries, they will just sign a bilateral treaty and will give advisory jurisdiction to the ITLAS. It could be good, it could be bad, but ITLAS has to be very careful, very cautious while entertaining, or it can use a discretionary power. It can use a discretionary power, of course, to reject that kind of advice. Further, since there are three now, this case has been filed in three tribunals. ITLAS, ICJ, and also Inter-American Courts of Human Rights. So there are so issues related to fragmentation are also there. The same provision can be interpreted in diverse manner. That is again one issue which has to be kept in mind. Further, of course, there will be benefit of if this matter is taken up by the ITLAS. ITLAS can interpret the relevant provision of UNCLOS, which are talking about the prevention of marine pollution. ITLAS will have an opportunity to interpret UNCLOS and adopt it to new challenges. Okay, so that was from my side. Thank you, thanks a lot. So I'm stopping sharing my slides. Yeah.
I take over. Yeah.
Thank you, Mohit. It was a wonderful take on the position of ITLAS. You have covered the important provisions of ITLAS and the previous advisory opinion rendered by ITLAS. Thank you for that. Now, to give a perspective from give a perspective from ICJ, we have, as I introduced, Nabeela Siddiqui. She's a colleague of mine and she teaches in Mission Law School in Chennai, where she recently joined as assistant professor senior grade. Over to you, ma'am. Yeah, please go ahead.
Thank you so much. I think Mohit came a bit more prepared than I am because he had the slides, and of course, the passion for the subject was quite visible. So, I don't have slides, so I'll just speak a bit. I think we can get along. And if there is any question, I think you can just post it along on the chat box. I'll be, quick to answer probably towards the end of the session. So, one of the most important factors I think which Mohit touched upon is from the perspective of it loss, and I'll be looking over more focused on ICJ. Now, before we actually look into the whole idea of what is going on, a little recapitulation, or let's say a little, refreshing of our memories as to how the whole procedure for advisory opinion works in the ICJ. So we all are aware that you have Article 65 in the ICJ, then you have Article 66. So these are the very important articles when it comes to advisory opinion when we talk about ICJ. So the most important paragraphs I would say would be paragraph 1 of Article 65, which tells you that yes, you can make a request for an advisory opinion. And how do you start about by making a request for advisory opinion? It can actually be done by anybody who is actually authorized or is actually adhering to the principles that have been established by the Charter of the United Nations. So anyone falling within these two categories as per paragraph 1 of Article 65 can actually file or request for an advisory opinion. Now once this request for advisory opinion is actually it's actually received by the registrar of the court, then what happens is we move further down to Article 66, which says then you by a matter of letter or any written document, you are actually it's actually communicated to all the states, and therefore you appear before the relevant court, and that's how you proceed. So now this request for the advisory opinion that we're talking about, the documents attached with it would actually throw light upon the question or the question of international law for which we are actually seeking the advisory opinion. Now, this is a very important document because it considers all the letters, interested parties, and also tells about the facts, how we are proceeding, how things would go forward. Now, this is very interesting when you look at the structure of ICJ, and you look into the order how which the request for advisory opinion is actually counted for. So you see that the states and the international organizations are supposed to provide all the relevant information to all the questions that they are posing as far as the matter subject matter on which they are actually asking or seeking advisory opinion. Now this is very important because if you look at Article 65 and if you look at Article 66, paragraph 1 each, and specifically para 2 of Article 66, you'll see that the registrar actually notifies, and it actually tells the state that is basically entitled to appear before the court, or maybe the international organization also concerned here, or even the president of the court. If he's not sitting, then you have to furnish all the information that is there and all the questions that you're raising, and then also be prepared in order to receive the written statements. But then there's a time period fixed, or it is a time bound exercise, and this will be basically be fixed by the precedent that is there, and therefore you have a public sitting that is to be taken care of. So this is the basic very basic rudimentary procedure that we follow when we request for an advisory opinion as per Article 65 and 66. And this is very interesting because it goes forward with the idea of filing written statements, and then transition of written statements, and then you go ahead for final written comments, and then finally you have written statements, written proceeding taking place, and then you have the oral proceedings which actually take place, and finally you get the court's opinion. And the court, when it delivers its opinion, it's done in an open court, and we've mentioned it under Article 65, and the rules also state that this will be an opinion that will be delivered in an opinion in an open court, and whereby you all the deliberations have actually taken place, and finally you get the text of the opinion which is is usually posted on the court's website. So this is basically the structure how the ICJ works when we request for an advisory opinion. So I just wanted to quickly bring this forward to us before we proceed to the actual crux of the topic. Now, one of the most important things that is happening recently, which I think Mohit has also highlighted, mine will be more concentrated with Vanuatu's whole idea of coming up with the seeking the advisory opinion of ICJ when it came to climate change. So the year 2022 marked a very epoch-making event. Now, when I say an epoch-making event, I would say it because 27th October, we are just about to, touch 27th October. So 27th October 2022, one of the most important events that took place was, the island, a very small island that is Vanuatu. Its permanent ambassador to the United Nations, his name is Odo. So Odo actually announced that we need to introduce a resolution to the United Nations General Assembly and seek an advisory opinion of the ICJ for on climate change. Now, of course, we are invoking Article 65 and the whole procedure that I talked about. But interestingly, this advisory opinion that we are seeking had a very peculiar feature, unlike any other matter that came before the ICJ. Here, you saw that you had a core group of at least ICJ champions coming up, a whole public momentum being created, which actually tried to develop a zero draft for the resolution. So it was a more people oriented, people driven movement which talks about the intersection of climate change and human rights protection. So this was very interesting to see that that first of all it was inspired by the youth, the young people that is there, and secondly it was an advisory opinion for the first time that was being sought on the matter of climate change, being brought before the ICJ. So I think this is two of the most important features when we're talking about this particular matter on climate change. Now, when you see that the youths are coming forward demanding about how there is a lack of efficiency within the given legal structure, especially when you're talking about United Nations convention on climate change. So this actually became a very big issue, and you could read a lot of reports, a lot of opinion pieces on this. And it was also interesting to see how climate change law and human rights law were actually being pulled together under this framework. And you saw that the human rights protection that we're talking about, it hinted towards the preamble of the Paris Agreement also. Now, here in this ICJ advisory opinion, as Mohit had already pointed out, one another matter was pending before the Inter-American Court of Human Rights. We saw that there were two separate spheres of law, two separate distinct places where we can actually expect a kind of a jurisprudence developing when we're talking about the deteriorating state of climate change and the aftermath it would have. Now, when you look into the ICJ very specifically, you see that this particular resolution that was brought about, it had one it actually was adopted on 29th March 2023, and we looked into the fact that you had a resolution text in front of you which was demanding the opinion of ICJ. So we saw 132 countries actually coming up together, and they all had consensus that that no state actually is opposing the advisory opinion, and there is no need to vote. So a kind of a ripple effect that we saw in terms of the international community, that was for the first time we saw this ripple effect taking place, the youth coming in front and the states having all consensus ad ideum. And probably it was also seen, a lot of people reported it to be a win for climate justice, especially when you're talking about the idea of development versus the environment coming into picture. So here we saw that the United Nations Charter and neither the United Nations Charter nor the ICJ actually gives you a framework for advisory opinion to be being legally binding in force kind of a attitude when it comes to its implementation, because it does bestows a very great moral authority that would there. It does have this, but at the same time it depends more upon how national level policies are being framed and how do you translate it in your own municipal laws. So if you see that at the early formative stage, or basically a matter of customary rule that we're talking about, so an advisory opinion does or it can actually strongly influence the behavior changes of the state, but also we need to see it that it also at the same time tries to create something called as opinio juris, we call it in international law. But moreover, both of these things more or less depends upon how the national community, how the international community would translate within the countries itself, and how the national authorities and the national laws would translate in their domestic laws. And this is very interesting to see, and especially when it comes to this particular issue that we are talking about. Because if I could recount very quickly, one of the most important events right now we are seeing is the Israel Palestinian conflict. Now we saw that ICJ in its adjudicating role, it has actually helped various concepts being developed, and a lot of jurisprudence being developed, especially when you're talking about international environmental law, especially when you're talking about transboundary principle, cooperation principle, due diligence principle, etc. But if you see that these outcomes actually have been achieved through advisory opinion, especially if you look into the recent case of the legal consequences on the construction of war in occupied Palestinian territory. That's the advisory opinion where we actually saw ICJ talking about the idea of right to self determination of people, being living in a very non-self governing territory. Now here it's a very interesting observation that the ICJ had. And even though a lot of people criticize at ICJ's advisory opinion and how it works out, but we see that in this particular case of Israel and Palestinian conflict, not less than 28 cross references have actually been made in the 3 pages of the opinion which the ICJ give. So you can see the mammoth amount of the value it has, and the credit it holds. Now when you come to our own position that we are talking about, or the position of let's say rather the current climate change issue, so what you can expect out of this pending matter that is in front of us is what I'll try to look into, and that's the crux, that's the main thrust of my discussion. So here if we look into, we'll see that this is not the first attempt where you are actually seeking advisory opinion on climate change on ICJ. You had other islands also, especially if I recall Marshall Islands, Palau Islands have actually, a decade ago, they've actually come in front and asked for similar advisory opinions, but they actually failed because of a strong political opposition that has been there. But since if we see how we've traveled through these 10 decades, we'll see that both the science, the law, the policy making, especially when it comes to climate change, has progressed, and it has changed immensely. Especially if you see in the latest report of the IPCC, that is Intergovernmental Panel on Climate Change, if you look at it, you'll see how we are talking about the emissions of greenhouse gases, and how we are talking about it being the dominant cause of global warming. Now it's a very well documented document that I'm talking about. And here if you see that they say that climate change has basically caused irreparable damages, and they're talking about the idea of losses and damages for the first time, and they're also talking about the idea of vulnerable communities and countries in the world that is there. So this is how far we've traveled within this particular the whole decade that has been there. Now one of the most important things that is there is, we see a lot of scholars have actually suggested that advisory opinion should be built upon a scientific consensus, and this is very interesting to see, especially when you're talking about climate change. Now if you look at the code actually can provide a very authoritative determination to the validity of the science that we're talking about, to the rationality that we're talking about, especially when you're talking about reduction of greenhouse emissions that is there, and you take into account the Paris Agreement whole temperature threshold that we talked about. But here if you look, the request for the advisory opinion actually looked into the scientific consensus, and it is embedded very much in the reports of the IPCC, that is Intergovernmental Panel on Climate Change. So basically, whether or not the ICJ is actually considering a scientific dispute or the science all in all, but the reports or the ICJ reports, we say, actually play a very important role in the whole exercise of adjudication and interpretation of the legal principles that is there. Especially this could be seen in the case of Japanese whaling case. Now this is a very landmark case in 2014 where we actually had an opportunity to see and testify how scientific community experts would directly testify in the court of law. So this was one of the most important events that took place. Now when you look at international climate change law and right to healthy environment, so we've recently seen that how ICJ has also felt the need to actually look into issues, especially when it commenced from 2015 Paris Agreement. We saw that a lot of stress was paid, especially when we're talking about the obligations, especially in terms of the conduct of the Paris Agreement. And it was very interesting to see that the ICJ actually relied upon an unanimous resolution. If I'm not wrong, it's called as the A76 resolution in United Nations General Assembly, which actually recognized the right to health, right to clean and healthy, sustainable environment as being a human right. Very recently, this happened. So we see here that how in this resolution the UNGA actually looked into related rights and existing international law, and how the intersection and the interplay between the both actually let us to fully implement the whole idea of multilateral agreements or principles of international, and how they would fructify in the judgments and even the policy making that is there. Now this is very interesting when you're talking about the whole idea of environmental jurisprudence. So if we go case by case and see, and then we'll come back to Veneto's stand. If we look at the ICJ's idea and its development of environmental jurisprudence, we see that it has been very gloriously doing that, especially when you're talking about the legality or threat of use of nuclear weapons. Now, especially when such crisis that are ongoing crisis that is going on, one of the most important judgment or the order advisory opinion that we see of 1966 comes into play. So we saw how the ICJ developed its environmental jurisprudence, especially when we talk about the legality of the threat of the use of nuclear force in 1966. It is there, and we saw how the ICJ actually recognized that environment is not basically an abstraction that you're talking about, but it also talks about the idea of living space, the quality of life that we're talking about, and how you are measuring the health of basic human beings, and you're talking about the idea of intergenerational equity, whereby people who are not yet born and even the future generations that are yet to come. So for the first time we saw that ICJ actually recognized the whole idea of the general obligation of the state, especially when you're talking about the jurisdiction, the idea of control of environment, and of course areas beyond the national control that we're talking about. So that was one of the most important judgments. And then you had the most important and landmark judgment. I think it will be very wrong if I do not mention it, the pulp mills case, and the Costa Rica versus Nicaragua case, and Nicaragua or versus the Costa Rica case, either of the ways that you can talk about. Now these are the very important two other contributions of ICJ when we talked about in terms of advisory opinion, because in mills case 2010, when we saw that ICJ actually considered the principle of prevention and precaution, and it said that if you look at from a customary rule perspective, you see that all of this has its origin in the due diligence principle, and it is required of a state and territory to actually have allegiance to these principles. Now when you parallelly come to the Costa Rica case, you see that that ICJ says that if you exercise the due diligence principle, you have to actually see what kind of a harm prior to the activity that you are actually indulging in, or a potential adverse effect it would have on the environment of the other state when we're talking about transboundary pollution that is there. So here you saw that how ICJ pinpointedly said that states are actually concerned with the conduction of environmental impact assessment, and it stressed upon the role and the importance of EIA that is there. Now one of the most important fact when we come back to the Vanuatu's case right now is what are basically the potential of this case when you're seeking ICJ's advisory opinion on climate change. Now one of the most important factor as to the outcome of this case that we can look or anticipate would be the fixation of the obligation of the state under international law. When you look in the Vanuatu's case, you'll see that ICJ is not only basically an organ of the UN that we are talking about, but it's also trying to interpret what climate change and its aftermath would have. And if you look at the advisory opinion very, if you look at very clearly, very, in a very holistic manner, you'll see that, it has talked about clear standards and benchmarks for climate action, especially in terms of economic contribution and how, this whole economical structure would, move forward. Now, when we looked at the objective of all the climate treaties that are coming up, we need to align them with the NDCs, that is national level, accreditation method that is there. So this ambiguity must be, actually removed when we're talking about international instruments. So this was one of the most important factors that you can actually keep a watch upon. And then the whole ambition to mitigate the GHG emissions, etc., that you can see again would be influenced by ICJ's advisory opinion, because it actually pledges, it actually makes the state pledge under the Paris Agreement, and actually see beautiful arguments coming from Vanuatu, where it is said, we are giving a clear signal, and this clear signal is signaled at two people, that is the present and the future generation, and we will leave no stone unturned in this critical decade that we are talking about, whereby we are laying stress on three things: human rights, justice, and intergenerational equity. Now, this was one of the most important and valuable, argument brought by the, the Vanuatu Islands. Now, this has also in turn tried to shape the national level and the domestic level litigations. Now, it's very interesting to see what are the very what are the very clear benefits of ICJ's advisory opinion would be its influence on the other courts, the regional courts, and the domestic litigations that is there. Now, if I don't mention here, one of the most important and progressive centers that we internationally have is the Sabin Center for Global Climate Change Litigation. Now, it is a very beautiful center. It's been relentlessly working on keeping a database, and it encapsulates. So if you, once we are done with the lecture, you can actually visit the website of Sabin Center for Global Climate Change, and the database it develops. It shows the domestic courts and how domestic courts and various countries are actually relying upon the international climate change law obligation advisory opinion of ICJ, and how ICJ's advisory opinion is actually giving a sense of a catalyst effect to homegrown litigation that is coming up. Now, this is very interesting because again you see that ICJ's advisory opinion has a greater outreach here, and therefore the idea of any question of international law is percolating through the through boundaries and even to the most local level courts that you can talk about. Another important factor that we can look into is the ICJ's advisory opinion is also giving us an opportunity to basically come as an authoritative statement when we're talking about loss and damage fund. Now, this is one of the most important factors and the most neglected factors that we've seen, whereby you see that a lot of international climate negotiations are coming up. There have been decade long conversation. There have been innumerable policies that has been there when you talk about the funding for loss and damage. But however, we see that there is no potential outcome of these exercises, especially until COP27. So it was only COP27 where we actually tried to talk about an operational loss and damage fund, especially when you're talking about vulnerable nations and vulnerable communities. Now, in this context, if you see, ICJ actually could basically provide a sense of a substantive ideas or obligations that would be responsible in the context of loss and damage. But these issues that we're talking about would actually also shape the transitional committee, which has been talked about in 2023-2022 in the Sharm el Sheikh, and actually recommend to operationalize this new funding arrangements that we are talking about. So it's a very interesting field of work that we are seeing. So the upcoming of this committee and recommendations that are there, ICJ could actually fill this gap and become one of the most pivotal pivotal organization or pivotal forum for voicing the idea of having a operational forum for loss and damage funds that we are talking about. Now, when you look at ICJ's advisory opinion and its influence on the international climate negotiations, you'll see that there's a general sense of frustration between the scholars of international law, because the whole process has been very slow paced, especially when it comes to negotiation, and especially when it comes to also consensus building between the nation. And this could be very true when we're talking about loss and damage. But here again, what we're trying to see is this opinion developing exercise is actually trying to stabilize, and also give a structure to expectations of the public at large, and also the private actors that are there. So basically ICJ is also trying to fill in these gaps and potentially coming forward, especially in terms of its advisory opinion. But then there are its own pitfalls, there are its own loopholes that are there. And when I talk about the loophole, I would definitely talk about the fact that when we're talking about advisory opinion, especially in terms of climate treaties, we are not actually they're not being actually very useful when you're trying to clarify the state obligation. So that seems to be one of the most slippery slope when it comes to ICJ's advisory opinion. But still it has an authoritative statement, still it does have its own impetus, its own value when it's talking about climate change. So I think yes, ICJ is actually trying to possibly do whatever could be possible. And if I could quote Philip Sands. So Philip Sands actually says that international court that we're talking about, ICJ, is actually a space in the global consensus that is being formed, and it is trying to actually uniquely contribute when it comes to climate sensitive global consciousness. But it more or less depends upon the national impetus and also national mobility these countries are trying to bring forward. So it's a very interesting contest of the rights of future generation that we're talking about, and how they are going to incorporate basic principles of precautionary principle, intergenerational equity, and due diligence, especially in the recent case that we're talking about. That is yet to be seen. But again, of course, this rights of future generation is the ICJ that we're looking up to. And let's hope how we'll proceed in the right direction. So that's from my end. Yeah.
Yeah, thank you, Nabeela, for the wonderful insights into the what could be the potential role that the ICJ could play in shaping the jurisprudence of climate change. So there are a couple of questions which are posted in the chat box. So for the sake of convenience, I can read those questions out. Uh, any one of you could respond to that. So the first question is pertaining to the sources. So what sources will the ITLAWs rely for providing advisory opinion? Will that a follow up to that is, will the advisory opinion of ICJ be broad than ITLAWs? So this
Yeah.
question. So can someone respond to this, please? Yeah,
Yeah.
Mohit,
Yeah.
maybe it's related to ITLAWs. You can.
Yeah. 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 So the law which will be applicable. So UNCLOS says in Article 293, it talks about law to be applied by the laws. So it says that convention and any other rule of international law which is not inconsistent with the convention. So which means that other treaties can be referred, even customary international law, any rule in international law can be referred, but it uses this term which is not inconsistent with the UNCLOS. Now, second question which you are talking about, like I think you are talking about the scope of litigation which is happening in ICJ and ITLAWs. So, when it comes to advice which has been sought from ICJ, there are two things which are being asked: scope of obligation on state parties, plus the question of state responsibility. If somebody has caused those or breached those obligations, then how that country will be made internationally responsible. But when it comes to its laws, only first part has been asked: what is the scope of obligation on the state parties to protect and prevent those issues, climate change issues, with respect to UNCLOS. The state responsibility question has not been brought when it comes to the ITLAWs advisory opinion.
When you look into the ICT, it's the other way around. So that's also one very interesting factor, because that's exclusively when we're talking about the idea of state obligation there. And also very interestingly, if it's possible and if you can get access to, there's a very interesting article. It's called as a game of give and take, the it laws, the ICJ, and provisional matter. So it is written by Loris Merotti, if I'm not wrong, if I'm pronouncing it right. Loris, Loris. So if you could get in touch with that article, that's a very interesting article where they talk about the whole idea of, it's a game of give and take. So what it's not handled by ICJ is actually transferred to it laws, and what's not handled by it laws is actually transferred to ICJ. So to say clearly, which has a broader ambit, I think Mohit would agree that would be a very again it would be a very interesting case
Yeah,
to case kind of a, yeah.
I have a follow-up question to Mohit. Actually, I mean, this it piqued my interest when this question was asked with regard to the sources. For instance, ICJ, as you pointed out, has rendered 27 advisory opinions till date. Meanwhile, this would be the second or third advisory opinion of ITLOS.
Third.
So, what materials would it rely? So, in the sense, like, what sources of law, in the sense, whether it will rely on UNCLOS, climate change jurisprudence, provisions of human rights, what specific substantive sources it would rely to provide these advisory
I
opinions?
think similar question was asked in the SRFC advisory opinion, because first of all, it is controversial whether it laws can give advisory opinion or not. And second is that which is the applicable law. So this question was taken up by the SRFC advisory opinion. So there also the court said that, like, so it relied on what is mentioned in 293 of the convention. It said that this convention can be used and other treaties can also be used.
Okay.
Yeah.
Okay. Nabeela, you want to respond to that? I understand it's part of ITLOS, so yeah. Yeah,
So
you're
I
on
think
mute.
that, yeah. So I think that,
Yeah, you're on mute. Nabeela, you're on mute. Yeah,
am I audible now?
yeah, now you're audible.
Yeah. So again, that's what I was trying to refer here, because what he's actually mentioned is just given in the paper that I was trying to mention. I've mentioned in the chat box. So if you look at it, it's actually a very, very interesting to see that it basically relies upon treaties, and as such, even I would be clueless to say what materials does it actually rely upon. So that's.
Yeah, there's another question that is asked. This question is regarding the potential risk. So, if the tribunal gives a negative verdict, or right, let's say a negative advisory opinion, I remember in some of the readings there is a reference made to the obligation to cooperate. So, if the tribunal or the court says states only have an obligation to cooperate, which is essentially an obligation of conduct, so will that be having a negative implication, or will it create a negative ripple effect when it comes to question of climate change in the future cases? If the tribunals and courts don't go that extra mile in fixing the obligation part. Like for instance, in the legality to the threat or use of nuclear weapons, the 1996 advisory opinion of World Court, the World Court did not give an advisory opinion. The question remained non-liquid. So, will this advisory opinion can potentially limit the scope of state responsibility? Whether that is a potential risk. That's the second question, if I'm right. Right.
Absolutely right, because when I was talking about NDC's national determined contributions that we're talking about, so if we actually looked into national determined contributions, especially in terms of Paris Agreement that we're talking about, it gives a reflection as to how the ICJ would moot upon an idea when we're talking about environmental problems, especially climate change, because that became one of the measures whereby we could measure how the countries are performing, how serious they are when it comes to greenhouse emissions and greenhouse gases. So that's one stakeholder that we have. So we need to have a standard for measuring how the countries would go ahead with. So an ICJ not actually giving a clear cut demarcated way would definitely be a retrospective. It will have a retrospective effect and take you back 10 years in time. That would be one, and also at the same time you're also negating the principles which have already been established. So I think that would be from the perspective of pure environmental law, I could rather safely say.
Okay, so I wanted to just add to it. Like, I personally think that even if they regard it, ICJ regard it as an obligation of conduct, not an obligation of result, I think even if that is the ruling, then also they have to go to next question, which is of
Mhm.
state responsibility, even if they have breached obligation of conduct. So I think because this things are happening, and the climate change is happening, global warming is happening, sea level rise is happening, and there are scientific evidences to prove it. So even if it is obligation of conduct, I think ICJ will go to the next question, which is state responsibility. I think which will be more difficult question because of the attribution thing involved there.
Yeah, that's true. And also, when you are also coming up with the idea of scientific consensus, as you rightly pointed out, that would also play a very interesting role. So, yeah, I think it would have a negative effect, and especially with the given issues that we are talking about. Because now we've also entered into the area where we are talking that yes, please include due diligence principle, please include intergenerational equity, please include all these principles, especially when you're looking into the Vanitu's argument. So yeah, that could be one.
Yeah, I think there's no further questions from the participants. So I would again officially thank, on behalf of the institution and HILSA and the Center for International and Diplomacy, Dr. Mohit Gupta and Nabeela, for enlightening the participants with their thought-provoking insights on some of the seminal aspects of the climate change advisory opinion vis-a-vis international law. It was indeed beneficial to all the participants, and I hope we also collaborate. Our institutions could collaborate for further. It could be on anything. It could be on research. It could be on certain conferences, talks, seminars, etc. In the days, I mean days ahead. I'll definitely be in touch with you guys for that. Your assistance would be required. And thank you so much again. I think it was in a very, very short notice, hardly a week. Both of you had agreed to enlighten or through for agreeing for this panel discussion. Thank you so much for that. And we also intend to hold a lot of sessions in person in the coming days, hopefully in the month of Jan. Here we have a long vacation for students. The next semester begins in the month of Jan. So from Jan we are planning to kickstart with more events, in-person events, where your assistance and your your assistance would be required. Definitely we could collaborate in a lot of our upcoming initiatives. Thank you so much again on behalf of the institution, and also all the participants who attended in large numbers. Thank you so much. Yeah, thank you.
Thanks
Thank
a
you so
lot.
much. Thank you so much.
Thanks a lot.
Thank you, Dr. Mohit. Thank you, Dr.
Thank you, Nabila. Thank
Thank
you.
you so much.
Thank you.